SJC-13445, Commonwealth v. Gene Rezac.
Attorney Warren, whenever you are ready.
Good morning, and may it please the court. John Warren on behalf of Gene Rezac, who is present with me here today in the courtroom. This case raises fundamental questions about culpability and punishment. It's about people with a mental illness that is so severe that they're unable to appreciate the moral wrongfulness of their conduct. Whether our society, through the common law in Massachusetts, says that those people are culpable, are they blameworthy? And is it right to punish those people?
Isn't really it about whether or not it's substantial capacity to appreciate the criminality or wrongfulness, or criminality and wrongfulness, and that whatever you think of Grudeau, the 2018 homicide instructions make clear which one it is?
I think that is the question, Your Honor. Is it both of these things, criminal appreciation and moral appreciation, or can it be one or the other? I think that's the question. And I think when you look at the Grudeau instructions, that they're ambiguous, because in one sense it's saying it's an or.
But what I'm saying is, I'm not sure they're ambiguous, although I realize that we say different things at different points in the, but it was before 2018. And the homicide instructions clearly say or, which is how I always instructed on it, because that's what I thought it was. And that's what not that that matters, but that's what the 2000 homicide instructions say.
And I think, but I think there's an ambiguity in Grudeau.
Well, not in the Model Penal Code, which it's based on, right?
The Model Penal Code...
It's brackets.
Brackets, right, Your Honor.
Which gives you the option in some jurisdictions, as we've adopted the MPC, sometimes we've said both. We've said moral and we've said criminality.
Exactly.
And we've said or, right?
So I think there is that ambiguity, and I think the Model Penal Code, it did have those brackets.
And in the comments to the Model Penal Code, they basically say it doesn't matter. They're usually the same thing.
And that's the point that the dissent in the Supreme Court made in the Kaler case a few years ago, to say, oftentimes we're talking about overlapping, these concepts are overlapping, criminal and moral. They often are overlapping.
Right, because if it's so immoral, it's usually criminal.
Right, I think, and I think the evidence would be similar, but I don't think they're the same. And I think the distinction is important, and that it's important for fact finders to be instructed on both and have to make a decision on both.
Are you talking about like the command delusion paradigm? That's
one example.
Then why is it significant in this case, or if that's just one example?
So I think it's significant in this case. I think it's significant, and I think when the Colorado Supreme Court decided this specific issue in 1992, I think their framing made a lot of sense to me in the way...
Was that Colorado case an MPC case, or was it a McCool case? I mean, not a McCool case, a right and wrong case.
So the Colorado case considered this exact question and said that...
In the context of the MPC?
I don't know.
That's actually really important.
Yeah, right. And also whether or not, or conform the conduct to the requirements of the law is present in Colorado.
Right.
I don't have the answer to that question, but if I could read this passage, because I think it gets to the reasoning why this court should include that moral component.
But Justice Cassiano's question is, why does it matter here? I'm really interested to hear the answer to his question.
Right, and I think this frames it...
On the facts.
On the facts. So, turning to the facts, we have an interesting case here because we have these two doctors who are saying, they're using their language carefully, and they're saying that during the attack, there was no moral appreciation. But then during this 911 call, there was a criminal appreciation, and their language tracks those two sort of scenarios. This was an episode that happened within minutes of each other. Someone who's severely mentally ill, clearly. Both doctors testified to that, and I think the records from the hospital support that. And what I would suggest is there was no sort of break in clarity within a few minutes. There was no break in clarity where all of a sudden she gained this moral appreciation. What I suggest Judge Sullivan was looking at was what to do with the fact that the 911 call incident showed some sort of a criminal awareness. That's what I think Judge Sullivan was wrestling with. What do I do with that fact? Because it does show, perhaps, that she knew that the police were coming. And I think the danger is that that gets fact finders away of what the question really ought to be, which is this mental illness so significant that it's impairing someone's ability to do that moral weighing of right versus wrong? And that's what Justice Cardozo was...
Right, but what I think what you give short shrift to, which I want to hear you, or give you the opportunity to address, is the volitional prong. Because if someone's under the command delusion, or if someone, as you just said, can't control themselves, then they get, then the government doesn't satisfy the volitional prong. So when you use the right and wrong test, which doesn't have the volitional prong, it's apples and oranges and frankly inapplicable. So I want to hear under the McCool test, the MPC, how this affects the volitional prong.
Well, I just think it's a separate question. I mean, these two prongs...
Yeah, but what you're saying is that it's unfair because this person is so mentally ill they can't control themselves. And my answer to you is, well, perhaps then they won't satisfy the volitional prong and it won't be unfair.
Because if they know it's criminal, but they can't get their arms around the moral implications and deal with that in a way that's going to allow them to be able to stop, then you can address that issue with or conform the conduct to the requirements of the law.
And I just think I would just suggest it's those two prongs. There's a reason we have those two prongs, and the Commonwealth has to prove both of them.
Right.
And one of them is tailored towards controlling your actions. The other is tailored towards your understanding. And that moral understanding of right versus wrong is wrapped up into that. And that's what
we've given you, the MPC says it could be either or it could be and. It depends on how the common law has treated it. And perhaps this court has not been as clear as it should be because we've used it interchangeably. Sometimes we say it's wrong, sometimes we say it's criminal.
But to this court's credit, it's never confronted the issue head on.
No, you're right. But when you raise the issue and say this is a matter of unfairness because someone who's harboring under these delusional command delusions, you have to strike your child because God is commanding it. You know it's illegal, but you think it's moral, right? So therefore, government doesn't prove the morality part of it. But then you get into the volitional prong, and then they say they couldn't stop themselves because they're commanded by this deity.
I do think the question's slightly different because it's controlling your conduct. And so I think...
Yeah, I can't control my conduct. My conduct is to strike my child.
But I guess what I'm saying is you could have a situation where you could control the conduct. And, I think this is pretty much that case because Dr. Saleh says during the attack she couldn't control her conduct during that one moment. But Dr. Murray says this is not there's no issue with that prong, controlling the conduct.
Right, so then we have a fact finder who chooses between two very good experts, essentially.
Well, no, Your Honor. No, because the case wasn't decided on that, or that prong, the Commonwealth has to prove both of these prongs.
Yeah, I know.
That's your argument.
Right, right. And, well, no, to back up, I'm talking about both prongs of the criminal responsibility test.
Right.
I'm not talking about within the specific wrongfulness.
Can we simplify this for a minute, what you're talking about? There's no issue in this case at all about a mental disease or defect.
Right.
And the issue here is whether or not, as it relates to the second prong, I usually call it, I would call that the third prong but let's call it the way you set it up in your brief. Prong one is there a mental disease or defect? Part two is, and part three, I'll skip part two for a minute, is can you conform your conduct to the requirements of the law? So the way you formulated McCool, is it appreciate the criminality or wrongfulness of the conduct, or criminality and wrongfulness of the conduct, and you say it's and you say it matters because when she's found not guilty of the most serious charges, and as it relates to the child endangerment and the intimidation, she knows it's criminal. That's why she takes the phone away and everything. But to her, it's not. She doesn't appreciate the morality, the wrongfulness of it. So you're saying the disjunctive or conjunctive matters in this case.
Exactly.
So if that's the case, that's the simple issue that we're looking at. And you're saying that, your words, not mine, you're saying that we've been sort of all over the place on that.
Not all over the place. I just don't think the court has dealt with it head on in the way that other states have, and the way that Justice Cardozo did head on in Schmidt in 1916, where he really tackled that question and looked at the history of the common law and came to the conclusion that really what we want to be talking about here is moral right versus moral wrong. That's ultimately the most important question.
Well, again, was that a right? That was a right and wrong case. It wasn't a McCool case, correct?
I guess I'm missing the distinction, Your Honor.
Because it doesn't have the volitional prong.
There's a safety net here in your
I
scenario that
understand.
protects defendants when the Commonwealth has to prove the case beyond a reasonable doubt. Because the Commonwealth can't just prove criminal or wrong. It also has to prove beyond a reasonable doubt that they lack the capacity, substantial capacity to conform their conduct to the requirements of the law.
Understood. But I think the same analysis applies, regardless of whether there's a second prong. I think that under this prong of wrongfulness, it is important to clarify that we require the moral component of that. And I think turning to why it matters in this case, I think Judge Sullivan's instruction was clear that it was an or. So why does it matter here? What's the prejudice here? I mentioned that we have both these doctors using that different language during the attack versus during the 911 call. We have Ms. Rezac's conduct.
No, I think your remedy is clear. I mean, you laid out that it goes back to him to apply the right test.
Right. Right, and we're not asking
If he using our language, our fault, not his, if he misinstructed himself, then he should have the opportunity to correct his instructions with better guidance from this court.
Exactly, and I think Your Honor's question in the prior case was interesting because we also have a case where a judge laid out what he was thinking. And I think there is some danger in reading too much into that because out of sort of respect for the fact finder. So I think if this court's wants to know what Judge Sullivan would have done under a different instruction, it should err on the side of remanding it back to him. But I do think his language of making that switch, why that switch with Ms. Rezac towards appreciation, his reliance on the fact of the ramifications of the 911 call is really revealing, because you can sort of see how he was dealing with, well, doesn't that show this criminal appreciation in the sense that the police might be coming? But again, I think that's going back to what Justice Cardozo was talking about. It's slightly different question than moral right versus moral wrong. And if I could briefly turn to the second issue in the case, if that's all right with your,
You don't have a whole lot of time to do that.
if there are any questions on the second issue, I suppose.
Okay, thank you so much.
Thank you.
I'm sorry. Attorney Hanson.
Good morning. Arne Hansen for the Commonwealth, if it pleases the court. With respect to the criminal responsibility issue, I don't believe there is any ambiguity. I believe the case law is very clear. The model jury instructions are very clear. It uses the word or, but if you go back and look at the seminal case, United States versus Freeman, on page 623, again, they use the words appreciation, understanding of the moral or legal import of behavior. So they use the or word as well. That seminal case also recognized that someone might be able to understand the criminal implications, but not the moral, and vice versa.
What about the way we phrased it in Commonwealth versus Dunphy with the either? And does the either go to the first prong or the second prong? Is that a little confusing?
I think it's important to establish that someone understood that their actions were wrong, and there's two ways that the court has allowed us to do that. One, by demonstrating that they understand that the police are coming, or two, more basic along the lines of this is good versus evil.
But Dunphy cites the model homicide instructions that have a more clear part of that.
But I'm not sure I understand
No,
the question.
Dunphy does cite the model homicide instructions, which has the delineation, so that it implies that the either refers to prong 2 and 3, not the sub-prongs, I guess, of 2. I'm talking to Justice Lowey. I apologize.
So I think it's important to look at Commonwealth v. Loya, and that's a recent case out of this court from 2019, which I think is a perfect illustration of why it's or, and why it should remain or and shouldn't change to and. Now, briefly, in Loya, the victim and the defendant were co-workers in the Coast Guard. They were good friends. One day, the victim tried to seduce the defendant, which took the defendant aback. There's no sexual contact, but he labeled it as the rape of the mind. The defendant was then transferred to a different Coast Guard base, and when he arrived there, he was reprimanded for his actions during that incident with the victim, which took him by surprise, which turned into anger. Now, at this point, the defendant's life deteriorated, and he blamed the victim for what ensued. Over the next couple of years, he became depressed, and his life completely fell apart. He became suicidal and was certainly someone who dealt with a mental condition. He resolved to die, but before he did so, he would take revenge upon the person who ruined his life. So in this case, he was certainly, from his perspective, he certainly felt that he was morally justified. So what he did is he went to the victim's home to kill her. He knew that these actions were wrong, and we know that because he knew the police would come, and his plan was to die by suicide by police officer, to kill the victim and then get into a shootout and be killed with the police. But he needed enough time to kill the victim, so he put his car in the middle of the road, lit it on fire, and he set up numerous booby traps and decoys around the house to buy himself more time. So certainly he understands and appreciates the criminality of his actions, but his delusions, in his eyes, he's justified. So this is clearly someone who can distinguish between the two prongs. And that conviction was affirmed, illustrating the point that it's not both, it's one or the other. Now, if we were to change the law and the Commonwealth would have to prove both, it would be impossible to convict this person because all the defendant, I understand the burden's on the Commonwealth, but all the defendant in his affirmative defense would have to do is present evidence that he believed he was morally justified. This person ruined my life. Everything fell apart. I became suicidal as a result of their conduct. I was justified in doing this, despite the fact that I knew it was wrong. I cannot be convicted. if the Commonwealth has to prove both. And I think that opens a very dangerous door, because you're, by definition, when we're dealing with criminal responsibility cases, we're dealing with people with mental disease and defects who have delusional and irrational thoughts. They are going to think differently, and they're going to spurn revenge based on something that a normal person wouldn't conceive as a threat. So to open the door for them to say, I have a mental disease or defect, I am suffering from depression, I'm bipolar, schizophrenic, all I need to do to get away with this crime is show that I believed in my delusions and therefore was justified in the actions, irrespective of any evidence that I knew was criminally wrong. So right now, the Commonwealth can use consciousness of guilt evidence to overcome the defense. You know, if you demonstrate that you took actions to avoid capture, to say that it wasn't you, or to diminish your role or to cover up the crime entirely, that can be used as evidence to overcome the criminal responsibility defense. That wouldn't happen anymore. I think we would be opening Pandora's box if this law's changed. I think I've made my point with regards to criminal responsibility. Are there any questions regarding any other portions or further questions on criminal responsibility?
I guess my question is, do you think our case law is clear that as it relates the criminality of wrongfulness, that it's clear that that's disjunctive?
Yes. So Freeman cites that. So what happened, I looked at Goudreau again in preparation for today's argument, and I think the defendant is trying to take advantage of what I perceive not to be ambiguity, but the "and" comment comes from page 738 of Goudreau. There's a paragraph there that defines what it means to appreciate, and the first portion of that paragraph states, appreciate the criminality or wrongfulness of his or her conduct. So it defines the test clearly. The second portion defines what it means to appreciate, at which point, and I'm quoting from the case, meaningful understanding and intelligent comprehension of the legal and moral import of his or her conduct. What the court is doing, they use the word "and" there, but I believe what the court is saying is that it applies to both. The meaningful understanding and intelligent comprehension applies to both the legal understanding as well as the moral understanding of the consequences of your actions. It's saying it applies to both of those prongs, rather than if you use "or," it might suggest it might only apply to one or the other.
Because when we have to be careful, because that was the situation in Alamany, because when we state what the government has to prove, it switches around, right?
Right. I do think that the case law is clear, and I think Loya is a perfect example of how the law works, because if it was both, Loya would not be convicted.